2 o'clock. Call to order the meeting of the Code Enforcement Board for the City of Tarpon Springs, May 9th, 2013. We let all rise and have Tom open us in prayer, please.
Heavenly Father, we gather together here today intent on doing good work. We seek to represent fairly and well those who have given us this task. May our efforts be blessed with insight and guided by understanding and wisdom. We meet to serve the City of Tarpon Springs, to use our resources wisely and well, to represent all members of our community fairly, and to make decisions that promote the common good. We recognize that our responsibility to the past and to the future, and the rights and needs of both individuals and the community. As trusted servants, we seek blessings on our deliberations and on our efforts here today. As we pray. Amen.
Amen. Please face us back to the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
They all whispered it. I don't know why.
You whispered?
Yeah.
It was solemn.
Loudly.
It's a prayer.
Well, not the prayer, the pledge. They don't know
The pledge is a prayer.
On the meeting, for one of the last meetings, on the minute, it said that you led us in the Pledge of Allegiance. I think this time Tom did.
No, I think
I could hear
I think he does every
really
time.
loud.
Bobby, if I could have a roll call, please.
Mr. Sanzota?
Here.
Mr. Casey?
Here.
Mr. Kramer?
Here.
Mr. Bessie?
Here.
Mrs. Archer?
Here.
Mr. DeMontis?
Here.
Mr. Slinsky is absent, Mr. Plunkett?
Here.
And Mrs. Dabbs is absent and excused. Please your roll call.
Thank you. It is the intention of this board to promote, protect, and improve the health, safety, and welfare of the citizens of Tarpon Springs by providing an equitable, effective, and inexpensive method of enforcing various codes within the City of Tarpon Springs. Any aggrieved party may appeal a final administrative order of this board to the Circuit Court. Such appeal shall be filed within 30 days of the execution of the order to be appealed. Florida Statute 286.0105 requires any party appealing a decision of this board to have the record of the proceedings to support such an appeal. The procedure this board follows with each case on its agenda is as follows. First, the city presents its witnesses and exhibits, after which the violator is able to ask the city's witnesses any specific questions regarding their testimony. Secondly, the violator is allowed to make a presentation and present any evidence or documents. Then the city can question the violator's witnesses. After both rounds of testimony, both on the part of the city and on the part of the violator, each party is asked to give a closing statement, first by the city and then by the violator. After those three steps are taken, this board then closes the public hearing portion of this case to discuss it and take appropriate action. Before we begin the public hearings, we will have all potential witnesses stand up and be sworn in by the Secretary of the Board.
Do you swear the testimony you're about to give whole truth and none but the truth? I do. Thank you. You can be seated.
He did not respond.
He
He did not respond.
You have to say I do. Stand up. Bobby, do you want to?
Okay, thank you.
Thank you. Thank you. Please turn off your cell phones or at least put them on silent. And we'll go ahead and proceed straightway to item number 1 on the agenda.
Good afternoon. My name is Cindy Sanner. I'm the Code Enforcement Inspector for the City of Tarpon Springs. This is case 13-200000013. The property address is 712 Lincoln Avenue, and the property owner of record is Marilyn Murray, and there is no one here in the audience for this case. Al, would you start the photos, please? On February 27th of this year, we received a complaint from one of the neighbors. This house had a fire and had been vacated since then. People were going in and out, and the owner was nowhere to be found. On that same day, I contacted the fire department. The fire marshal stated that the fire investigation had been completed, so I conducted a site visit and found that the house had been destroyed by fire. There was no front door, and all of the windows were open. There was trash and fire debris on the property. The property was in violation of codes 6-1, building code, and the IPMC adopted, IPMC 108.1.1, unsafe structures, IPMC 301.3, vacant structures and land, 8-22, accumulation of trash and debris on private property, and 8-40, duty of maintenance of private property. A notice of violation was issued on February 27th of 2013 to the site address and to another address on file located in Clearwater. An amended NOV notice of violation was issued on April 1st, 2013, and a notice of hearing was sent via first-class mail and certified return receipt on April 19th of 2013. All documents were returned. A site visit was conducted prior to each notification going out. The property was posted on April 25th of 2013, and yesterday I conducted a site visit and found no change. This property is in violation of code 6-1, IPMC 108.1.1, IPMC 301.3, 8-22, and 8-40. I recommend a compliance date of May 28th of 2013 and a daily fine of $50 per day thereafter.
Board have any questions for the city?
How long has this been like this, Cindy?
Well, the first I was made aware of it was on February 27th.
And you want the fine to run from today?
No, compliance date of May 28th in 2 weeks.
I'm sorry, I just have to question that. If you were made aware of this on February 28th, why are we pushing the date up to May 28th?
Because there has to be time after the hearing for compliance. So I'm just asking for a little over 2 weeks. Because notification has to go out and it's common practice.
That's typical for all these cases, every one of them. We want to give them time to comply. It's not, I was just talking about this earlier, we're not here to make money, we're actually here to assist the residents, and so this works with them and shows that we're willing to work with them. So now they're aware, and
Yeah, but if we were made aware of this February 28th, and, you know, I realize this is probably a legal question for Mr. Pratt. February 28th, we've gone through March, April, and now we're going through May. That's 90 days. Don't we also have an obligation to the people in the area to have this cleaned up? I mean, it would seem to me if I lived next door to this and they still had another 2 weeks to clean this up, I don't know as though that's being extremely fair to the people in the neighborhood on Lincoln Avenue. I know some of the people on Lincoln Avenue, and it just doesn't seem to be fair. Now, if that's the law, then there's nothing we can do about that if it's the law.
the way I figure it, if they had an issue with it, then they have an opportunity to be here and voice their complaint. They also have an opportunity to complain to the city. In fact, that's probably how this initially came to Cindy's attention, was from somebody's complaint. But it is what it is. We've got a couple of weeks, and this is pretty typical. I think it would be taken into consideration the residents that live close by, but we also have to take into consideration the person in which has been levied the fine. And this gives them a reasonable amount of time. It's not unreasonable. And after which, it's going to be a substantial fine to the person if he or she doesn't attend to it. And so it gives them 2 weeks before a substantial fine will start.
Yeah, and I'm not even convinced that $50 a day is a substantial fine based on the fact that this was February 28th. Obviously, the owner knows that it was burned on February 28th and has done absolutely nothing to clean it up. I mean,
Yeah, but we don't know why. It could be insurance. It's hard to say. But at least this puts some it pushes them into action. Bobby, will you receive those photographs into evidence, please? But I think 2 weeks is reasonable now that it has come to the board.
Cindy, have you ever talked to this Marilyn Murray?
We can't locate her. We've searched the internet to try and find alternate addresses, and the only two that we found were the site address and then an address in Clearwater, and we've done, like I said, they've come back. I have no idea where this person is.
And you think $50 a day is substantial?
Well, considering the fact that nothing has been done so far, I doubt if anything in the future is going to be done. If she's not aware that, the property was posted, but if she's not in the area and she's not aware of today's hearing, I think $50 a day is adequate.
Did she live at this house?
Yes.
She did?
Yes.
She was living there when the house burned down?
It's my understanding that she did.
Well, in a month, it'll be a $1,500 fine. So.
It is only 2 weeks. I mean,
No.
Well, it's only 2 weeks from today. It's not 2 weeks from when it's,
You can't make the fines retroactive. You can't go backwards with, because the person has to be duly, properly noticed, and then we follow State Statute 162 as far as the process.
Any other board discussion? Would somebody like to make a motion?
well, I will.
Okay.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violations, Section 6-1, IPMC 108.1.1, IPMC 301.3, 8-22 and 8-40 of the Code of Ordinances of the City of Tarpon Springs were enforced. The resident has until the 28th day of May 2013 to come in compliance with code sections, or a fine of $50 per day shall be imposed for each day thereafter the respondent remains in violation of said code sections.
Second.
Okay, thank you for the second. Board discussion on the motion. Bobby, if I could have a roll call vote, please.
Mr. Plunkett?
no.
Mr. Marcus?
Yes.
Ms. Archer? Yes. Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Mr. Casey?
Yes.
Mr. Sansoda?
Yes. Okay. Motion carries. Item number 2, please.
This is case 13-200000015. The property address is 118 East Tarpon Avenue. The property owner of record is Dennis Kappas Sr. The location is the Taylor Arcade. The business owner is G.A. Morphosis. His business is Eccles and Company Incorporated. This is proactive. While investigating another case, I happened to find out from the Division of Corporations that there was a business at this location that was operating without a city occupational license. This property was in violation of Code 11-1 occupational licenses. A notice of violation was issued on March 19, 2013 to the property owner and to the business owner. A notice of hearing was sent via first-class mail and certified return receipt to both parties on April 22, 2013. We received a phone call from the property owner, Dennis Kappas, on March 25th. He stated that he rents out the suites but has not seen this renter in a long time. The property was posted on April 25th of 2013. Yesterday, we received a call from Karen Lane in Development Services stating that the business owner, Mr. Morphosis, applied for and paid for his LBTR, which is the occupational license. It is presently in review. This property is in violation of Code 11-1. I recommend a compliance date of June 3rd of 2013 or a daily fine of $25 per day thereafter.
Any discussion? Anybody?
Somebody has to approve the application.
It has to be approved by different departments. It has to make its rounds. Don't foresee any problems with it.
Okay.
Somebody like to make a motion on it?
I'll make it.
Thank you, Peggy.
I move based on the testimony, evidence, facts presented in law that at the time of the alleged violation, Section 11-1 of the Code of Ordinance of the City of Tarpon Springs was enforced. The respondent has until the third day of June 2013 to come into compliance with the code sections, or a fine of $25 per day shall be imposed for each day afterwards that respondent remains in violation of the said code.
Second.
Okay, any board discussion on the motion? Roll call, please, Bobby?
Mr. Plunkett? Mr. Plunkett?
Yes.
Mr. DeMarcus?
Yes.
Mrs. Archer?
Yes.
Mr. Bessie?
Yes.
Mr. Kramer?
Yes.
Ms. Vicasey?
Yes.
Mr. Sansoda?
Yes. There are no affidavits of noncompliance, and save the addendum, there's nobody in the audience for the affidavits of compliance. And so if, Bruce would, thank you, Bruce.
What happened last month?
We didn't do it. No, there was an election.
I move we accept the affidavits of compliance on case number 0980000597, case number 12-800000925, case number 12-800000927, case number 13-800000042, and case number 10-200000042.
Do we have a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. And then the affidavit of compliance on the addendum sheet.
You read it already?
Is that already?
You read it.
Okay. Well, I just was moving to, I'm sorry, okay, so, the request for reduction in fine, item number 2.
Presentation is written in your packet.
Okay.
Remember, these are done in the
Now, you all have had time now to study the, what was, presented by the property owner and what was presented by the city. Has everybody had time to do that, and they are comfortable with the information?
Yep.
If so, would somebody like to make a motion on this?
I'll make a motion.
Thank you.
This is, for reduction in fine. And let me find the proper terminology.
Very last page, Alan.
Last page.
Okay. I move, what is the fine, Bobby?
$102,000.
How much?
$102,050.
102,000?
103.50?
No, 102.
103?
102.50?
102.50. I move that the fine of $102,050 in the case of citation number 10-2000042 be reduced to $2,500 to include all administrative costs. This reduction will occur upon payment of the stated reduced amount if paid within 60 working days of this order. Failure to pay the reduced fine will result in the original amount of $102,050.
Second.
Any discussion on the motion?
I'd like to make some discussion.
Sure.
If the administrative costs were listed at $250, why would we have a recommended fine of $2,500 if our costs were only $250? I guess my suggestion.
Well, that was the city's consideration. I put a lot of weight on the city's suggestion, and there's been a time or two that we've modified what the city suggested, but it doesn't happen very often. But if the motion fails, then you are certainly up to reduce it even more. We already have a motion on the table, but it's a city recommendation. I'd be honest, if it was left to the board without a recommendation, typically we'd go 90%, which would then be a little over $10,000. But again, I don't know. I didn't question Cindy as to why. No, that's great. Wanda, go ahead.
Well, I think maybe cut and dried violation, it may only come to $250, but maybe there's more involvement, which got the amount up to $2,500. But if that is the case, instead of getting it down to $250, which I wouldn't mind doing, why don't we give him longer? Because his letter states that his employment situation isn't great right now, and if we just let him have maybe 6 months to do the $2,500, that might make it easier for him, and I don't want to scare him off.
Al, if you want to amend your motion, or we can leave your motion as it stands, and if it fails, then make a new motion.
Well, again, I like, what Wanda said, and what you said, Mr. Chairman, was that came from the city, and I have to believe somewhere along the line that Cindy has probably talked to the owner of the house. Obviously somebody has, because it says in his letter that he is aware that the Code Enforcement Board can reduce the fine. And I know that in the past we have reduced it. We normally, under normal circumstances, we reduced it to 10% of the original fine is what we did in the past. Now, I'm not saying that that's what we have to do now, but I'm going by what was recommended by Cindy, and I believe that, again, that Mr. DeLong has probably talked to somebody about the reduction, and I think that $2,500 seems to me to be extremely fair in the amount that we're talking about.
All right, then we'll just take a vote on the motion as it stands. Any other discussion before we do so? Bobby, if we could have a roll call vote, please.
Mr. Plunkett?
Yes.
Mr. DeMarcus?
Yes.
Ms. Archer?
Yes.
Mr. Bessie?
Nay.
Mr. Kramer?
Yes.
Mr. Casey?
No.
Mr. Sansoda?
Yes. Well, it's good conversation. Thanks.
May I say something? Last name.
DeLong.
Mr. DeLong, I was very touched by your letter, and I am so proud that you chose Tarpon Springs as your new home.
Thank you.
That's wonderful. Come halfway around the world. That sounded very much so.
I would like to second that. I think that I would have been more generous if it was possible. We're lucky to have you here. Thank you very much.
Good luck.
Thank you. Thank you. Thank you. There's no old business. Approval of the last 3 months' minutes. If we could have a motion to approve the minutes, please.
Do we need to do it 1 month at a time, Tom, or just both?
You can do them all at one time, so long as you just reference the date that you're in the motion for all three. February 14th, March 14th, April 11th.
I move to approve the minutes of the meetings for February 14th, March 14th, and April 11th
2013.
of 2013.
I'll second that motion.
All those in favor, say aye.
Aye.
And opposed?
I can't do anything with one. I mean, it's February, but I can't do the others.
You can vote on it, even though you weren't here at the meeting.
Okay,
Yeah.
and I'll approve.
Okay. Motion carries. Any, public comments? Board and staff comments?
We had no affidavits of non-compliance.
No.
Well, you're just doing a heck of a job.
Wow. 2:25, and, we sit adjourned. Thank you very much.